about this federal court ruling that came down 2 Fridays ago.
Essentially, we lost, actually, quite some time ago about the data being revealed to the U.S. government, that is metadata. And the government essentially argues that metadata is not the same as content, therefore they can issue an administrative subpoena, a so-called 2703D order, and this administrative subpoena has a much lower bar than, say, a search warrant. And it can also have a gag. In fact, most of them seem to have a gag. Twitter was able to unseal this so that we could begin to fight it. We lost, and it's quite sad. They received the data, but we appealed again about secrecy of docketing. That is to say that we believe that courts should have to keep accurate records of this type of an order and other orders like it. And we were hoping that we would be able to learn that there were other companies out there and that we would be able to challenge this phishing expedition.
Explain what happened to you. Why did they get your account, all your information in Twitter?
Well, I mean, many people from the government have said during detainments and other times in which they have confronted me that I should understand why this is happening. But the reality is that I don't understand why it's happening in a legal sense, at least until now. Now the government argues that I should understand that this is the case, and it's this case because it's as secret as a grand jury proceeding. And there is, in fact, a WikiLeaks grand jury where they have been pressuring people. In some cases, people have been threatened with effectively indefinite detention if they don't comply, that, you know, they let people know there's really not...
What does it mean to comply?
Well, if they ask them a question, they'll either forcibly immunize them or maybe they'll threaten them with just detaining them without really explaining what will happen. There's a lot of pressure coming from a lot of different angles. So what the government is effectively saying with this ruling is that they want to have not just secret laws and secret interpretations, but no accountability. And this is something which I think is pretty scary. And I think we should have public laws, public interpretation, and public accountability. And this is what we see is more of the same. I mean, we see this with the targeted assassination, the indefinite detention, and NDAA, and this is just the internet version of that, where they've decided they don't even have to get a search warrant, and I have no right to resist it.
So what do you think, what are the implications of this ruling for government surveillance, and what the limits are on government surveillance, if any?
Well, I think in the United States the gloves are off, and when I was here with Bill Binney last, I think he pretty much explained that this is the case.
The former NSA, National Security Agency.
Yeah, I mean, the secret interpretation of Section 215 of the Patriot Act seems to be that anything that the government wants is fair game without a warrant, and that's terrifying. And this seems to be the tip of the iceberg. As we know from that video with the FBI woman that I met, she seemed to indicate that there was a national security letter. So I think these 2703D orders, they're important to be considered as the tip of an iceberg of an investigation. So there are probably other types of legal orders. And so I think it's important to stress metadata in aggregate is content.
People are having trouble understanding you. Metadata in aggregate is content.
Absolutely. What that means is that if you look at one event that I talked to you via email, in theory that we talked is a piece of metadata. The content, that is what I wrote in the email, that is in theory protected and you need a search warrant for it. But if they know that I talk to you every single morning, that tells a story, maybe even a really important story. And maybe if they see that I talk to Dan or they see that I talk to other people, that also tells a story that is equal to content when it's viewed in an aggregate. And that's something that's quite terrifying because the court doesn't seem to recognize that, nor do they recognize the location privacy issues with the internet. And that is to say they watch and see every place that I've been, they get this data, and then they have a tracking device effectively. Now in my case, I use the Tor network in order to protect my location anonymity needs, but most people don't, and they expect the rule of law to do that for them. So imagine their surprise when it doesn't.